my name is Noor Ashlisa binti Saidi. My metric number is 056019.
Assalamualaikum, my name is Nushara Adila binti Azmi and my metric number is 055250.
Assalamualaikum, my name is Amiza Alisha binti Azmi and my metric number is 055137.
My name is Nurul Azani binti Azmi and my metric number is 055125.
The concept of common heritage of mankind is an international legal theory or principle which is defined territorial area and aspect of humanity. Common heritage should really be held in trust for coming generation and safeguarded against exploitation by individual nation, government or corporations. The Common Heritage of Mankind Principle (CHP) as introduced the United Nations General Assembly in multiple declarations and treaties and as comprehended in the beginning 21st century states that all nations own the natural resources of the deep seabed and outer space, which should be distributed equally and fairly for the benefit of all mankind. The principle of CHM is an essential element of the United Nations Convention on the Law of the Sea. It exclusively applies in relation to the regulation and management of the resources which lie outside the limits of national jurisdiction as for any other principle of international law. The context within which the principle of CHM has been developed is essential to understanding the philosophy behind it, its evolution, and more particularly the challenges faced today for its effective implementations. The concept of common heritage of mankind was controversial when it was initially established in the 1960s and it remains so now. This debate involved problem of scope, context, and status as well as the connection of CHM to many other legal concepts, and it will be discussed in this video.
Let me first dwell on the status of the seabed areas and its resources. The change deriving from the declaration of the seabed to be the common heritage of mankind compared to the existing law of sea are twofold. They cover a negative side as well as the positive side. As to the negative side, it was agreed from the beginning that the appropriation of the seabed area as well as the exercise of sovereignty or of sovereign rights over any part thereof was prohibited. This rule was already laid down in Operation Paragraph 2 of the Declaration of Principle governing the seabed and the ocean floor, and the subsoil thereof, beyond the limit of national jurisdiction. From there, it found its way into Article 137, Paragraph 1 of the Convention on the Law of the Sea. So far, the legal significance of the Common Heritage Principle is trifling, as Article 2 of the Geneva Convention on the High Sea Order prohibits any claim of sovereignty thereto. Just as a point of interest, it should be mentioned that according to the original Common Heritage concept, there was no room for the establishment of exclusive economic rights of coastal states, and the enlargement of the continental shelf area has as enshrined in the Convention of Law of the Sea. Compared with the negative side just mentioned, it is the positive sides of the Common Heritage Principle, which is the declaration of mankind to be the one to dispose of the seabed and its resources, which introduced a revolutionary new element, mankind in turn into represented by the Seabed Authority. Thus, the seabed, which under the Geneva Law of the Sea is an area beyond national jurisdiction, has been placed by Convention of Law of the Sea under the jurisdiction, though limited, of an international organization. Consequently, the regime of utilization of the seabed altered is corrected completely. There exists a logical link between the status of the area and its resources and the utilization regime. Attention should be given in the respect to Article 137, Paragraph 2 of the Convention on the Law of the Sea, which prohibits the alienation of the resources of the seabed, and to Article 1 of the Annex 3, according to which title to the minerals depends upon whether the recovery was undertaken in accordance with the Convention. To avoid any misunderstanding, it should be emphasized that the establishment of an international organization empowered with a resource-oriented jurisdiction is no peremptory consequence derived from the Common Heritage Principle. It will have been possible to stick to a solution more in line with the existing structure of the international community of states, which results in leaving the administration on the common heritage to the individual states. The state will then add not. The states will then act not on their own, but in the absence of international organization, in the capacity and organ of the international community.
The notion of the common heritage of humanity was controversial when it was initially established in the 1960s, and it remains so today. The scope, substance, and status of common heritage of mankind, as well as its connection to other legal concepts, are all at stake in this debate. As one commentator describes, it questions the regimes that apply to resources of global significance, irrespective of where they are situated. It therefore challenges traditional international law concepts such as acquisition of territory, sovereignty, sovereign equality, and international personality, as well as the allocation of planetary resources and consent-based sources of international law. In the literature on the law of the sea and the outer space regime, voices have been heard which attach another legal significance to the term mankind. For instance, relying on strand of arguments and followed by regards the introduction of the term into international treaties as a step permitting mankind to become a new subject of international law. Thus, they regard the common heritage principle to be a so-called third-generation human right, however, deny any legal significance to the term mankind. A compromise position which attaches some legal significance to the term seems to be most preferable. The adoption of the term mankind from the Outer Space Treaty, taken together with the term heritage, at least indicates that the interests of future generations have to be respected in making use of the seabed. More substantively, it requires that deep seabed activities should avoid undue waste of resources and provides for the protection of the environment. It still remains problematic to translate this prohibition of undue waste into reality. However, at least it should be accepted that the status of the seabed and the resources necessarily influences the structure of the utilization system. Any broader interpretation which suggests that not states but mankind must be regarded as a direct participant with respect to deep seabed activities does not take into account that only states and international organizations have the capabilities necessary to participate directly within an international legal community. The replacement of states by mankind would necessitate the establishment of an international organization vested with the legitimacy to represent mankind as such without the interposition of states. According to the Convention on the Law of the Sea, such a conclusion cannot be drawn. The last controversy of common heritage of mankind is the demand that the seabed should be used for peaceful purposes only was based on two grounds. First, it was argued that as the utilization of the seabed should be carried out for the benefit of all mankind, and that since any military use from its very nature only served national interest, all military activities should be prohibited. Secondly, it was pointed out that the military use of the seabed might interfere with deep seabed mining. Discussions arose only with respect to whether any military activity on the deep seabed should be banned or whether aggressive activities only were to be prohibited. All in all, can be proven there are numbers of issues regarding common heritage of mankind. Those issues will surely always be debatable by many parties, and law should be improvised from time to time to cope with this matter.
Moving on, I will be explaining about the importance and the controversies of the concept of common heritage of mankind over the high sea. Alright, first off, the common heritage of mankind principle, as presented to the United Nations General Assembly in various declarations and treaties, and as understood in the early 21st century, states that all nations own the natural resources of the deep seabed and outer space, which should be distributed equitably for the benefit of all humanity. So one of the importance of the concept is that the common heritage of mankind principle was presented with the understanding that it was crucial to plan for future exploration and uses of these important regions in order to ensure not only an equitable distribution of their natural resources, but to prevent conflicts among nations as have occurred during earlier eras of exploration. Additionally, we create a very important opportunity by utilizing common heritage of mankind as an overarching normative concept to strengthen and commit in moral solidarity and legal form to the goal of safeguarding and restoring the seas as an interconnected ecological system. This demands a clarification of the link between protection or restoration and human usage, because ecological integrity is clearly a requirement for the long-term well-being of all species, including people. Its protection or restoration must be a clearly expressed objective. Now, moving on to the critics of the concept of common heritage of mankind. Firstly, it raises concerns about the rules that apply to global scale resources regardless of their location. According to Boslar in 1997, it raises questions about traditional international law ideas, like territorial acquisition, sovereignty, sovereign equality, and international personality, as well as planetary resource allocation and consent-based sources of international law. Furthermore, it has long been recognized that the precedent set for ocean management has the potential to serve as the foundation for the future organization of a global community that is becoming increasingly interdependent. Additionally, the common heritage of mankind is seen as a potential hindrance to investment and the application of market incentives, such as property rights, to achieve economic and environmental advantages by developed states and commercial interests. Next, developing countries opposed the adoption of common heritage of mankind in the 1992 United Nations Convention on Biological Diversity, viewing it as a possible threat to their sovereign rights to use and benefit from biological resources inside their own borders. They were distrustful of meddling disguised as environmental protection or the acquisition of intellectual property rights. Furthermore, the principles of affirmation of equitable sharing and open access to space resources and technology will result in stagnant inefficiency in their growth, resulting in less benefits being created for all parties involved. Lastly, the United Nations Convention on the Law of the Sea and CLOs did not apply common heritage of mankind to the entire ocean ecosystem as a complex and linked ecological totality. This resulted in ecological nonsense, exposing much of the oceans to classic concept of state sovereignty, such as creeping claims of sovereign authority, common property, and freedom of the high seas. Therefore, we can conclude that despite the advantages of the concept of common heritage of mankind, there are also some critics or controversies about it.
In a short term, and from the perspective of state practice and treaty negotiation, the future use of CHM is likely to be limited. Issues that will shortly test the commitment of state to CHM include the status of marine living resources of the area and high seas. In the context of the oceans, CHM provides the only current alternative to either freedom of use by all states or the addition and exercise of sovereign rights. CHM is also relevant to the wider debate on transforming the role of the state from exclusive focus on protection of national interests to include responsibility to protect ecological systems wherever they are located. For the benefit of all, CHM is also important to the broader discussion of shifting the state role from only protecting national interests to include protecting natural systems whenever they may be found, for the benefit of everyone. State may be reluctant to offer the potential use of CHM, but international law is no longer the exclusive domain of state and international lawyers. Global civil society is increasingly involved in the creation and promotion of concepts like CHM. It is connected to a growing interest in multiculturalism, global constitutional government, global ecological citizenship and justice, and the desire for common ethical values to lead development toward a more peaceful and sustainable future for everyone.